Good morning, California. This is a meeting of the Legal Affairs Committee of the California Citizens Redistricting Commission. And we'll start off with a roll call. Director Hernandez.
Yes, thank you. Chair Sadwani, Commissioner Sadwani, I'm sorry.
Yeah, I'm hoping I'm not chairing this. Yes, present.
Okay, it's earlier than normal, so I apologize.
Yes, it is.
Commissioner Toledo.
Here.
And Commissioner Yee.
Here.
Roll call is complete.
Thank you. Let's start with opening public comment. Christian, general public comment at this time.
Yes, Chair. Just a moment. In order to maximize transparency and public participation in our process, the commissioners will be taking public comment by phone. To call in, dial the telephone number provided on the live stream feed. It is 877-853-5247. When prompted, enter the meeting ID number provided on the live stream feed. It is 882-7101-2900 for this meeting. When prompted to enter a participant ID, simply press pound. Once you've dialed in, you'll be placed in a queue. To indicate you wish to comment, please press star 9. This will raise your hand for the moderator. When it's your turn to speak, you'll hear a message that says, "The host would like you to talk. Press star 6 to speak." If you'd like to give your name, please state and spell it for the record. You are not required to provide your name to give public comment. Please make sure to mute your computer or live stream audio to prevent any feedback or distortion during your call. Once you're waiting in the queue, be alert for when it is your turn to speak, and again, please turn down the live stream volume. And there are no callers at this time, Chair.
Thank you, Christian. We'll wait a moment, and while we're waiting, I'll mention that there are handouts for today's meeting. The purpose of today's meeting is primarily to review the litigation contracts or litigation counsel contracts for our two litigation counsel firms that the commission has agreed to pursue. And those contracts have still not actually been executed. So we'll be looking at where that's at today. And so the copies of those are in the handouts for today.
And those instructions are complete on the stream, Chair.
Thank you, Christian. Okay, we'll go ahead and move on to item 3 on the agenda, discussion of proposed edits to litigation contracts for Gibson Dunn and Crutcher and Stormwasser Wutcher. And I'll hand the meeting over to our Chief Counsel, Anthony Payne.
Good morning, Chair and Committee. Good morning. By way of introduction, again, I want to introduce Tim Trikelt, who's also our contracts attorney. He's been very helpful in assisting us so far, especially with these contracts. So thank you, Tim, for joining us this morning. If I could, I'd like to recommend that we start with the Stormwasser Wutcher contract. As you can see, very minimal amount of recommended edits from the Stormwasser team. In fact, you'll notice in one part of the contract, we clearly anticipate paying for Mr. Becker. And so I think they're just clarifying that point, which maybe certainly happy to hear from the committee, but we fully intended in doing that. Specifically, it would be under looks like number 4 under subcontractors, look like page 9 or 10. Let me see, not page 9. They've added a line, notwithstanding the terms of this section, CRC agrees to reimburse contractor for the legal services rendered pursuant to this contract by attorney David Becker at the hourly rate specified for Mr. Becker in Schedule B1. That's I would argue, is the one maybe clarifying change. So I would be fully supportive of making that change, and any other. I think there's an introductory change that they've recommended. I would be fully supportive of the few changes that they've made, and if the committee would agree with that, then we would hopefully go to the full commission, perhaps with this change. and for approval to finally get this contract executed.
Very good. So the clause regarding Mr. Becker, it seems like it's simply a billing matter then,
Yes.
treating him as a separate contractor rather than
Yes.
as a employee of the firm.
Yes.
Very good. Any discussion? Let's see, do we need a motion for this? Oh, go ahead, Commissioner Toledo.
The only thing the only thing that is that he is listed as and I don't think it's a big issue. I think it's technical, but he is listed as senior counsel in our compensation, matrix, implying that he's an employee of or somehow affiliated with
Scrum Master.
And when they applied for the contract, they didn't. It wasn't specified whether he'd be an employee for them or a subcontractor for them or whatnot in the original proposal to the commission in the RFP. So this, while it doesn't seem, it seems, at this point it seems minimal. It does. I'm just pointing that out that when they applied, they didn't tell us whether he would be a subcontractor or not. They implied that he would be an employee.
And I think we're to your point, Commissioner Toledo. I think this is probably, from their perspective, probably closing that loop a little bit on their part.
Sure.
If they're an employee, if Mr. Becker's an employee, no problem with paying for services. But we say, well, hey, wait a minute. If they're a subcontractor, that may not be the case. So I think they want to say, well, what if he's a subcontractor? You still plan on paying Mr. Becker, right? So I think they're covering their bases with this, whether he's a subcontractor or he's an employee, I think is the motivation.
So it actually leaves it open.
Well, I think it covers, frankly, my interpretation of this is it covers Stromwasser, whether David Becker, we're going to be able to pay. We are paying for David Becker, whether he's an employee of Stromwasser or whether he's designated as a contractor of Stromwasser. We would still be paying for those services.
Right.
And it's only fair to pay for the services rendered. So makes sense, right?
Yeah.
We get a service, we have to pay for it. So.
And with this, if I may just chime in here, does this change any of the administrative ways of how they are billing? Are they billing generally as Stromwasser plus Becker, or is Becker sending in separate bills? And does that create any additional burden on staff, right, to have to pay additional bills? Regardless, I completely agree with Commissioner Toledo. We're going to pay it one way or another, but just trying to assess if it has any additional burden on the commission.
Sure. So to your point, Commissioner Sadwani, I think I don't think it would create extra sort of staff logistics, primarily because what Stromwasser will do is they will say, here are our billables as attorneys, and then here's Mr. Becker's invoices and the basis for those charges, and they come once, they come together. So I think they'll be reviewed together, even though they are separate.
Thank you.
Okay.
Given all of that, I have no problem advancing that contract.
Should we have a motion? Or is the consensus sufficient? Because the full commission will need, the approval of the full commission is what matters here, I believe.
We can make a motion to recommend to the full commission if we so choose.
Okay.
I don't know if it's necessary, but we can.
And I'm happy to second if need be. Is it necessary, Anthony, or is it?
No, I would envision that as part of the subcommittee report or the committee report, that might be a recommendation that would obviously need a first and a second to be approved by the commission. So you're right. Ultimately, that's where it needs to go. How it gets to the full commission is fine.
I'm happy with just a consensus, just to skip the public comment. Okay. Okay. So I believe that's all for the Stromwasser-Witcher contract then. Please proceed with the more complicated matter of the Gibson Dunn contract.
Thank you. So with the Gibson and Dunn contract, we received some pretty significant edits to our counter, and so what you have posted is our proposed counter to what they've essentially their response to ours. So what we have here, and Tim's been very helpful in this, is providing a proffered response to Gibson and Dunn. And I would also recommend that perhaps because of the level of detail that this would entail, that perhaps it makes sense to have a subcommittee to help assist finalizing of negotiation details, only because I will tell you, logistically, a lot of work went into getting this counter. We were able to get our contracts team on board with changes, as well as Department of General Services chiming in on that, because we want to make sure that they're on board with it as well. It doesn't do the commission any good to negotiate a final contract that Department of General Services isn't going to ultimately accept. So we had to run a fair amount of traps for this. And if we get future iterations of this, to help facilitate finalization, whether that is an adoption of the contract or not, which ultimately has to go before the commission anyway, it would make things, I would say, more efficient. So that's just a thought. I'm certainly happy to see what you all think, but just from a working logistics standpoint, that would help ease, I think, a lot of the time constraints that are obviously in existence with this.
Anthony, why don't you give us a little characterization of the scope and nature of the changes and why this one is more protracted? And
Sure. Actually, Tim, I don't know if you would like to give just a flavor to the committee about this. I mean, including the binding arbitration and that sort of thing, why maybe that's something we wouldn't do, and why we opted to not do it, include that in our counter to them.
Yes, thank you, Anthony. Well, commissioners, the binding arbitration that was proposed by Gibson Dunn Crutcher is not necessary, because the state has its own process required by the Department of General Services to address any issues of conflict in the contract. So we've deleted their proposed arbitration because we're required to adopt the standard state process that the Department of General Services provides for. So that's that. And then regarding the rest of the contract, if there are any questions on that process. So the rest of the contract was mainly we addressed some minor things like invoicing and placing and invoicing is consistent. Every month we get an invoice regardless of charges, so that we know that there's no charges. That was one of the issues. Standard conditions have been incorporated from the Business Professions Code 6072, which is required by Department of General Services. In the area of conflicts of interest, we consulted the state bar rules of conduct regarding the required conduct of attorneys. We incorporated that into the contract so that it was clear that they applied. There was some confusion. We thought that the commission may be waiving its rights by agreeing to something else, because that's something that can be done under state bar rules. It could be the rules can be waived if there are other in writing, if there are other agreements. So we opted to incorporate by reference the state bar rules as they stand alone as being the guiding clause for conflicts of interest and attorney conduct. In addition, we adopted the recommended language from the state bar that requires the attorney to provide all papers, all documents at the end of the contract to the commission and keep them. And we required them to keep these documents in their office for 10 years after the conclusion of the contract to assure that this commission and the next commission have access to the legal working papers of any litigation that might occur. We clarified that the resumes and the background material for all of the attorneys that are on staff shall be provided with the contract, and that any changes shall be provided. If there's attorneys that leave or come, they have to be provided as well, so that we can evaluate for conflicts of interest, and also just for our own record keeping and the commissioner's knowledge of who's working on the contract and their backgrounds. We clarified a few things with the travel and per diem expenses. There was an issue about whether or not that extra expenses could be allowed, and Cal HR does provide for going beyond the standard rates when it is justified because of availability of vendors. And so we included that, but we are consistent with the Cal HR rules as they apply to all of state government, and that is what we have included rather than having it at the commission's will.
Tim, I'm wondering, could you maybe address the Prompt Payment Act in Exhibit D3? The reason why it might be helpful to discuss that is because the ability for the commission to obviously pay its bills, and whether we can work something else out. Because I believe that part is statutory, so that's not something that we can work a different process out.
Correct, and the final contract, and I'm scrolling to the to D3. I think it's on page 19. Well, at any rate, the process for payment of vendors, contractors by the state during times of budget crisis is consistent throughout government, and that's the process we have to follow. The actual, and I see a mistake. I see that the numbering is off here. 3 goes to 5 on confidentiality of data. My apologies, missed that one. But anyway,
So while Tim's looking at that, I just wanted to mention that to the committee, only because our hands are frankly pretty tied when it comes to, I mean, there's an existing process for addressing any paid dues. As we all know, we're all familiar with the statutory and constitutional requirements that apply to the commission, that we're obviously are going to be good stewards of the state's money, but it's not, the being paid is not something that's contingent upon satisfaction for or some sort of special approval that frankly most departments have to go through. That's certainly an advantage for us, but that should frankly give any firms contracting with us extra assurances that it's not like they're not going to get paid. So I just wanted to at least raise that so that you all are aware.
It was actually an issue in 2011, and became quite a conflict actually. So, yeah,
and they did get paid, right?
They got paid, but when further work needed to be done, and it would have been subject to a forthcoming allocation, that wasn't in place yet. Actually, they terminated their work, and the other firm that we were using at the time was willing to wait for payment, and so and they got the remainder of the work. So it seems like a sticking point for them. I don't know whether the same conflict could happen again. As it happens, we are budgeted much more generously this time up front, so it's not really.
I think the overriding principle in the attorney-client relationship is that although we're bound by the rules of disengagement, they still have an obligation to us as a client under the state bar rules of professional conduct to make the transition in our best interest upon termination of the contract, for any reason. So that I think is overriding protection for the commission. If there is an unlikely occurrence, there could be a contract suspension because of non-payment. They can't just leave us, just close the door on us. They have to take care of us as we transition.
Sure. And I believe that happened. I mean, ultimately all cases were concluded in our favor. So, okay. Well, that's quite a list. Maybe we actually need to look at them one by one. Let's see. So that's the prompt payment situation. Commissioner Toledo?
Yeah, just to the points about the prompt payment, because we did mention that to Gibson Dunn as part of the negotiations for this contract, right? We talked about it with their staff, and so they were aware of past issues as well as some of the limitations that we have, and were willing to express willingness to work with us on it. Back many months ago, that was back in the spring. I guess the question I have is, it seems like many of these edits are clarifying edits, and not. I mean, there's certainly some that are more substantial than others, but some of these are just clarifying edits. When I go through these, that might actually be good to incorporate even into the Strumwasser contract, because they do clarify some things. Although I'm not advocating that. I'm just seeking advice from you guys on that, because some of these clarifications protect both sides in terms of, and I think Strumwasser has our best interest in mind, but more clarity is better than less. So I was just wondering about that, and maybe we can prioritize the substantive issues rather than some of the. Some of these are just really clarifying, and not substantive, and not aren't changing the meaning of the contract.
Commissioner Samani?
Yep. To along a very similar vein, I was just curious about one of the additions that was mentioned was a vetting of any new personnel that is added to their contract. And I did want to just make sure that we include that also for the Strumwasser contract as well, if possible. It's not a deal breaker, but I do think that the two should be treated similarly on this piece. And in particular, I know that Strumwasser has added a couple new members to its team. I don't recall if we put those new staff members through the same vetting process that we engaged in prior to initiating their original contract. So I would love it if staff could look into that piece.
No, I think so. To both your commissioners' ideas, we could absolutely essentially incorporate those clarifying changes, as you say, Commissioner Toledo, that protect both sides of them, both sides. So we could absolutely do that. And I, as you say, I'm sure Strumwasser would be happy to engage with us on that. So if that's the committee's will, I'd be happy to work with Strumwasser to do that.
Is there any benefit or disadvantage to doing that?
I don't think there's a disadvantage at all. Well, to be completely fair, there's certainly an advantage to both parties for greater clarity. I suppose a disadvantage is it would delay any finalization, but at this point, I think Strumwasser has been very forthcoming, and they certainly have a lot on their plate, but they were able to get me any sort of responses. They've been very communicative. So I don't believe, in my opinion, that this would jeopardize, from a timing perspective, any approval of the litigation contract for us to maybe take another pass at this, to maybe include some items, some clarifying items. So that's the only disadvantage, if you will, that I can think of, is that instead of, it might be more into the future when we can finish this. But as I said, they've been pretty communicative. So I don't ultimately see that as a problem.
And it's
I'm wondering though,
my-
go ahead, Commissioner Toledo.
Oh, thank you, Chair Yee. It's my understanding these contracts don't go into effect until after January anyway. I could be wrong. I'm just trying.
Well, actually, it's December 27th, right?
Oh, that's right, December 27th. Thank you.
The third day of Christmas.
Yeah.
I'm wondering, I mean, that's all good, but I'm wondering, do we then need to go through each of these point by point? I mean, are we going to assume that everything that we land on for Gibson Dunn should apply to Strom Moss or Witcher, or are we going to need to discuss whether they would differ at any point?
But we certainly could. Another option is for we could come up, both Tim and myself could come up with just a substantive list that's sort of I don't want to call it a top 10, but we would remove the clarifying questions and go through and kind of have a discussion over each of the substantive and how they apply to each of the contracts. We could just go one by one, and you could then see how they apply in the Strumwasser context, in the Gibson Dunn context, and we can do it that way if you'd like. That may be the most helpful. That's just another option.
Okay, that would be helpful. Let's see. I think that would take you some time though, so we would need to have another meeting at some point.
Sure.
Yeah. So nevertheless, we go through the rest of these, I guess, at least to take a first look at them. See, Commissioner Silvani?
Yeah, before we do that, I certainly agree with this approach. I was just curious, was there a sense, just kind of how this was brought up with these two contracts? I'm hearing that Strumwasser has been very communicative and, responsive to the changes of the contract. Is there a sense about the responsiveness of Gibson Dunn to these proposed changes?
No, I mean, I would say Gibson Dunn has been communicative as well. I've certainly, if I'm measuring the delta between the time the commission has reached out and the time we've heard back, I would say Strumwasser has been a little bit more responsive or quicker, but you could also make the other argument that Strumwasser already has an existing relationship, so maybe there's a little bit of a quicker response there because of that. I don't know, but the important point I wanted to, at least at the very minimum, highlight for you all is there are some Gibson and Dunn has raised some substantive changes and recommendations in our counters that we did not receive from Strumwasser in theirs. And so I wanted to bring that to your attention and see what you have for a path forward in the interest of concluding negotiations, whether that's with or without a contract ultimately. But if we have counter, then counter, then counter, then counter, this could get pretty prolonged. And so I wanted to raise that for all of you, noting that was a difference between the two contracts. And so I want to be mindful of time. I want you all to, as you all know, we have to incorporate Department of General Services in substantive changes. There's some logistical piece on our end that we have to do. So and I'm trying to be mindful of the time frame as well. And as I mentioned, I know we still have some more time, but I want to raise that and see what you all would like to do as sort of a pathway. Whether you come up with different counters, for example, that's fine. But how would you like to proceed? For example, one option could be. We make any changes the committee would like, and we provide that counter to Gibson and Dunn, and then we hope to hear back from them as soon as possible, and I can come back before the committee again with the change, with changes to and what our counter would be in response to that. That's certainly an option. So far, to get to this point, it's been at least, and I would hope that now maybe the delta would be shorter, but it's been a little bit of a time. I would say at least a month and a half to get to this point. So I just don't want us to get to November and the beginning of December without a contract.
Sure. Commissioner Samani?
Thank you. Yeah, I think that's actually really helpful because I was trying to understand the variations between these two contracts. And what I'm hearing is that the variation exists given the negotiation process that has ensued at the staff level. And I think that was really helpful just for me to hear. And in that sense, I mean, I would be happy to move forward despite those variations in the two contracts. In the interest of time, because I share your concern. Starting October, when we move into line drawing mode, it would be really great to have a sense that these contracts are nearing the finish line and about to be signed, because I think most of our attention will be there. And honestly, this has been a very long process, right? We began engaging in this a very long time ago. I mean, the initial RFPs went out in, what was it, December, Commissioner?
Yes.
So it would be great to expedite this process as soon as possible. And so despite those variations in the contracts, I think the description that you laid out of how we arrived at this point was very helpful for me, and I would feel comfortable to move forward, though I know there's some additional discussion to have.
I think I'm still not clear. I don't have a good sense of how much back and forth remains. I mean, there's been quite a few, the counter and the counter to the counter were quite lengthy, and major issues. The whole binding arbitration issue. I mean, I guess it's surprising that if that is statutory, then, why did that even come up? And is there anything here that could actually torpedo, the possibility of retaining the firm if we just can't come to eye on something? I don't have a sense of that, or whether these are actually fairly minor things that almost are matters of style than real substance. Mr. Trinkle?
Well, just a comment on that, I think one of the major concerns of the firm was in the area of conflict of interest, that they might be prohibited from doing any work for the state, other work. And we clarified that the conflict that they might have would be a direct conflict. And they're free to work for other state entities, governmental entities, in a variety of capacities, as long as there's no direct conflict with their work for the commission. And that, I think, they seem to be very concerned about that. I wrote some language in to try to address it, but I think it's very simple. It's in the state bar rules. It's in statutory law. So it's clear that they shouldn't have that concern based upon our review. That was one thing. And then the other components that we reviewed, I felt were just simply, besides the binding arbitration, were simply just matters of, we really have to, as a matter of public policy, follow the rules of the Department of General Services. And I think they're in a position, they did the ask and they got the answer that we must follow DGS guidelines. And I can't see them as being deal breakers from my standpoint. Because we try to protect them, their interest, as well as protect the commission and the public's in the process.
That's helpful. Thank you. Let's see, I'm thinking of going up backwards through the list that we made of items. So the Prompt Payment Act, any further discussion on that one? Okay, then personnel changes. The only thing I noted is there seem to be 2 additional personnel that they're listing now whose names we had not seen before. And I think we actually do need to vote to approve personnel changes on the commission. That's true. Both would be true of both firms. So we'll need their, resumes and everything, and actually bring that before the full commission at some point. and do the conflict of interest checks. Any other discussion of personnel? Retention of documents. I was just wondering about the 10 years. I mean, does that cover enough time going forward for the next commission to have access? Because, I mean, would 12 years maybe make more sense to get them well past their litigation window, 2030, 2031? I don't know.
Easy to do. I think would 12 years be your recommendation? We could go further. We thought 10 from the end of the contract, which we anticipated would be, next year, but 12 might be, we can add 12 very easily.
I mean, it's imponderables, right? But more time doesn't hurt in this case.
I agree. So 12, we'll make those changes.
Okay. Any further discussion on that? Okay, then back to the conflicts of interest clause. That was the counters were quite complex. So if it is just a matter of them assuring themselves that they can take on other work for the state, that seems fine. My initial worry was that, are they trying to open the possibility that they could represent someone adverse to the commission, simultaneously? I imagine that's a matter of state bar rules that you can't do that, but I'm a lay person here, so maybe you can assure me that that's not the case.
You cannot, as long as the state bar rules of professional conduct apply, but they may be waived by written agreement. So our concern is that the contract could be viewed as a waiver of some aspects. So we felt it was best to stick directly to the state bar rules and make them overriding on the contract.
Right. Okay. So then, if I understand it correctly, they had suggested a possibility of waiving some of that, but then we are countering, no, we're going to stick to the.
I don't know that they actually suggested it, but I think that their language could be interpreted as a waiver, and we didn't want that in the contract.
Sure.
Just clear up some ambiguity.
Yeah.
And the state bar rules, in my opinion, fairly, they're designed to fairly protect the lawyer and the client.
Sure. Okay, any further discussion on the conflicts of interest clauses? If not, the last one I had was the binding arbitration matter. And as you mentioned earlier, we're simply reverting to the standard DGS rules on that. So I don't know if there's anything more to say about that. Why it even became an issue, or I don't know.
I think it was probably just something that it's hard. I don't want to attribute motivation for it, but it could be that's just what their standard ask is when they engage in contracts, sort of regardless if it's a state entity or not. So I think it's one of those things where they probably just have it in everything. And if there's something as hard, which is in our case, why we couldn't even accept or be able to do that, then I just think we let them know that for their purposes, we're a special case. And this is why we can't do it. And I think that's a substantive difference, but I don't think it's, I wouldn't want to attribute a particular motivation behind it necessarily.
Sure. I suppose it just, here they are, a top firm, and I'm assuming we're not the only state contract they ever executed. So I would think they would know something like that.
On the other hand, maybe they're hoping we would agree. I don't know. I don't know. I don't know. I mean, as you're aware, binding arbitration, there's pros and cons to doing that, right? Just as a policy or just a general knowledge of, is binding arbitration a good thing or a bad thing? There's a list of pros and cons with a yes. There's pros and cons going with the no. So anyway,
I agree, Anthony. And their proposal appeared to be, the firm that they suggested appeared to be the kind of thing that they would by standard put into all their contracts. And the other thing is that it would be it violated the Public Records Act by making some information confidential that can't be confidential. So we couldn't accept that.
I suppose it just surprises me that they wouldn't have known all that upfront. Yeah.
Yeah.
Standard.
Okay. Any further discussion of the binding arbitration matter? Okay, so our chief counsel is recommending that to make the process go more quickly, that we perhaps form a subcommittee that can meet more frequently going forward for the next few weeks that this is still churning along. So we can discuss that. Commissioner Toledo?
My understanding when we tried to form a subcommittee of this committee in the past was that a subcommittee would be a quorum of this committee, and therefore we couldn't. So I'm just wondering if that is possible.
Well, so yes, so you're right. So to your point, and perhaps if I could just make a suggestion, maybe there's one member from this committee and another commission member not in this committee. And then you've addressed that concern, Commissioner Toledo. That could be an option.
Well, it could be the incoming chair, which happens to be Commissioner Sadwani, could appoint a subcommittee of this committee, or on paper, I mean, it could be a separate subcommittee. Right?
It could be a separate subcommittee of the commission, right?
Yeah.
And
be like a contract subcommittee or something of that nature.
Litigation contract subcommittee. Yeah. Which I think that would be okay, right? What do you think would be best going forward? Yeah.
When's our next commission meeting?
Tomorrow.
Wow.
Oh, then that's perfect, right? Commissioner Sadwani could appoint.
She's all set.
I could appoint the two of you, and not myself.
Outside of this committee, yeah.
You would certainly be great on that subcommittee, Commissioner Sadwani, but you have a lot going on.
I have no problem sharing the wealth of this work. Yeah.
Would there be any advantage to considering any other commissioners? Commissioner Fernandez has a lot of contract experience. I mean, it sounds like these issues are not. I'm getting the sense these issues are not going to be intricate and prolonged to work out. Commissioner Toledo?
So the only advantage I would think of having someone from the Finance and Administration Committee also join one of us would be that less on the contract negotiation side, but more on the accountability afterwards once we have the contract in place, like knowing all of the rules and having gone through the process, and just for billing purposes and for paying the invoices, and so knowing all of the agreements we made in the contract is important for them as they're charged with making sure that there is payment and making sure that it's appropriate and it's fair, right? So it might be good to have someone from that committee involved in the contracting aspect of it, at least. But at this point, it's so far along, it may not make sense.
And they would have to look at it anyway.
Yeah,
when it actually happens.
One way or the other, they're going to.
Yeah.
So actually, to that sort of related to that point, aside from perhaps a contracts committee created by the commission, and actually separate from that, would this committee want us to proceed with the preferred counter back to Gibson and Dunn, with the understanding that anything has to come back before and be approved by the full commission anyway? So again, I'm trying to think of a kind of being the most efficient with the timing of that. If you're okay with that, sort of a two-pronged approach. There's the counter that we would be providing to Gibson and Dunn, and separately, perhaps the chair of the commission would be able to, if the motion or if the recommendation for the commission is to have a subcommittee to assist with finalizing this as well.
Okay, so then we're thinking about everything we've discussed this morning, and I guess you're asking if it all sounds good and whether we're ready to we have a consensus to forward the counteroffer. Any
And
further?
That's great.
that
Okay.
counteroffer does not require approval by the full commission. Is that correct? This can just simply be a recommendation of the Legal Affairs Committee.
Well, yes, and here's why. Because anything that substantively that changed from what the commission previously approved would have to go before the full commission. So, say for example, we provided this counter to Gibson and Dunn, and they signed on the dotted line. We would still have to bring it back to the full commission for approval. So yes, ultimately everything has to be approved by the commission.
And in fact, it sounds like our proposed counter actually strikes the substantive, changes that they had offered or had proposed. Binding arbitration, conflicts of interest, prompt payment. That's all reverting to state statutory language. So,
which was in our original. So
right. So the open question is, will they accept that? I guess that's the big question.
I mean, where we can, we're obviously for purpose of negotiation and protecting our interests and both parties' interests. We want to try to work to, come to a resolution on this. But yeah, further negotiations will be needed for sure.
Okay, so at this point, do we just seek a consensus to move forward with the counteroffer? Any objections?
Chair, if I could just because we're going to ask, assuming we're going to ask the full commission to create a committee, subcommittee. I believe the report out would be a recommendation of the Legal Affairs Committee to do that. So at a minimum, just on that point, it would be helpful if we had a vote on that, because that's a specific recommendation from the committee. I think everything else, because it has to go before the commission anyways, could just be a report out.
Okay.
That would be helpful.
So I'll make a motion to recommend to the full commission that it form a litigation contract subcommittee.
And
Was that a second? I'm sorry.
yes.
Okay,
yes,
Commissioner
yes.
Sadwani, seconds. Any discussion? Christian, can we take public comment on the motion on the floor to recommend to the commission that it form a litigation contracts subcommittee?
Yes, Chair. The commission will now take public comment on the motion on the floor. To give comment, please call 877-853-5247 and enter the meeting ID number 882-7101-2900. Once you've dialed in, please press star 9 to enter the comment queue. The full call-in instructions are read at the beginning of the meeting and are provided on the live stream landing page. And there are no callers in the queue at this time, Chair.
Thank you, Christian. For our next trivia contest, we're going to ask if anyone actually remembers the call-in number for public comment.
Would that be correct, Chair? The language there?
Yes, motion to recommend the commission to form litigation. Yes, that's fine. Thank you.
And those instructions are complete on the stream, Chair.
Thank you, Christian. Let's proceed with the vote.
Very well. Commissioner Sadwani,
Yes.
Commissioner Toledo,
Yes.
and Commissioner Yee.
Yes.
The motion passes.
Thank you. I believe that concludes first part of item 3. Second part was any VRA legal issues that we needed to discuss. I'm actually not sure of anything.
No, and I just wanted to have that agendized in case we needed to discuss that, but I'm not foreseeing any particular one unless any of the committee has anything.
No, not at this time. My understanding is we will have a little bit more of a conversation about that tomorrow with David Becker and Megan Gall during our full commission meeting.
Okay, anything else we need to discuss today? We're not even to our first break.
An efficiently run meeting. Very good.
Yeah, that's kind. Okay, if not, then we can
it looks like Commissioner Toledo has a question.
Oh, I'm sorry, Commissioner Toledo.
Yeah, thank you. Just a quick question about utilization of our current legal firm and how that's going based on. I'm just curious about utilization and maybe it should be a future item because it's not on the agenda, but just utilization compared to what we anticipated would happen. It's both a budgetary but also a legal affairs question as to our spend, but also just the best use of resources, right? In terms of as we go into the line drawing process, that's when our spend's going to kick up. I anticipate based on how many of our attorneys are present at those meetings and the long hours and such. And so just curious if how we monitor that. And I know you're monitoring that, Anthony, and I know we don't need to get into the weeds, but maybe if there were some kind of report that could be brought to this committee on our hours and like budgeted hours compared to what we're actually spending, so that we or however you want to do it. But in terms of our oversight, we should have some oversight over utilization of legal services per the contracts.
Yeah,
I'm sorry. No, go ahead.
No, I was just going to say, I completely agree with you on that, Commissioner Toledo. And I certainly, it's been on the back of my mind when we have meetings and there's multiple members of the Strumwasser team at times present. Sometimes members who say nothing. And I'm just wondering, is that necessary? Are they there to help fill gaps on the back end, perhaps? And, I think the challenges with Mr. Becker's schedule, I understand the need for additional members of their team, but from time to time, but sometimes I do wonder how necessary it is, or is it just an opportunity to build a commission doubly?
So happy to talk generally about that, of course, to your point, Commissioner Toledo. I will absolutely we can bring this back. My understanding, and I can reference this since this is already in the public domain, the partner, Fred Wucher, has mentioned that there have been a few times where I think he's been cognizant of a number of Strumwasser public faces during a meeting, and he's openly mentioned, like, we're not being charged for everybody that's on here. And I know that's been the case in a few instances in the past. Happy to, in a future meeting, go through when that's been the case, just to sort of highlight that point. I do think, Commissioner Toledo, to your point, I think it's going to be, we are going to have to keep an eye on this, especially when we're going into the line drawing phase. Exactly who needs to be there. The commission, and rightfully so, has publicly again had a desire to have Mr. Becker there, and for certain portions of it, to be sure. It does get a little tricky, and Commissioner Sadwani, certainly defer to you on this, but how we need to have our VRA counsel there also while we're having our line drawing. It's a little difficult to know in advance, oh, well, we won't need our VRA counsel there but for the last 30 minutes, but we can have the line drawer team there for 90% of the time. I don't know if we can thread that needle from a financial perspective. It would be great to do that, but I don't know if that is ultimately efficient for the commission, because if there's a line drawing VRA issue that comes up, but we don't have our counsel there because we're trying to save them for the end, or we front load them, you know, it might actually make the process more cumbersome, and it may be more difficult for you all to get the feedback you need almost real time, or at least helpful for the line drawers. Otherwise, then you can start backing up. And so I foresee that being admittedly a pretty significant expense. But if there's no way to know it in advance, which I'm not sure it would be, I don't know how we could shave that part of it. And I know that's going to be a significant, it's going to be a significant expense for October and November. I will continue to look for ways to see if we can do that. I will let you know, and in the public know, I've certainly, as you've mentioned, Commissioner Toledo, I've tried to, be very efficient with the communications we make, that it's with particular and the correct individuals, so that we're not incurring additional expenses where we don't need to. But I will continue to make sure that we do that, and kind of look for more ways to make sure that we're stretching the dollar as far as possible.
Commissioner Toledo?
Yeah, I think what would be helpful also is, what types of questions, VRA questions are for us to understand, because I think maybe Commissioner Sajwani and others understand this better than I, are so important that they have to be addressed on the spot, right? Or that they couldn't be addressed by through our counsel, or so. I mean, and I'm sure there's probably quite a few. It just be good for us to understand what those are, so that we can justify the spend on it, right? Because it is significant spend. So if we say these are the types of questions that might arise, especially in these 10 districts where there are VRA concerns, or where we've identified or whatnot. So it's just a little bit more, just so we understand our oversight abilities a little bit more, and are able to fulfill those responsibilities.
I will say the billings we've received from Stormwater so far are hearteningly detailed. So they do specify exactly who worked on what and all that. So, and I imagine from their point of view, certain meetings they don't want to fly blind and not know what we're talking about, what we're doing, right? So, but sometimes that may not be necessary. So, okay, I'm thinking. Let's say earlier we talked about maybe a top 10 list to talk through again, but as I'm thinking about these issues that we've discussed concerning the contracts, I don't think any of them, as long as the counters don't get countered again by something substantive, I'm not feeling the need to reconvene this committee if we're appointing a subcommittee, as long as it doesn't go, substantially beyond the scope of what we've discussed today. So can we just leave that on the table then? This committee will convene again, but only if there's really substantive counteroffers that need further discussion. We don't need to go through the details of things we've talked about today again. Does that sound good? And then the only other open question is the additional personnel. How do we go about doing the background research? And then I guess we could have them approved when we approve the contracts. That would be fine. But so Anthony, maybe you can tell us, is staff able to do the background work on them to get a conflicts of interest clearance on them and a recommendation? Or does this committee need to do any of that work?
I'm happy to make sure that we get that done in-house, so that's not something that you all have to spend your time with, if you're fine with that. They also have to, there's some disclosures that they're going to have to make per the contract as well. Is that right, Tim?
Yes.
where they're going to help essentially with that conflicts check as well. But we're happy to do that piece as part of
Very
the
good.
negotiations.
Okay, very good. And we'll just anticipate that when we move towards the final approval of the contracts. Okay, anything else?
I don't think so.
If not, let's go ahead and take final closing comment. Christian, general public comment on items not on the agenda.
Yes, Chair. The Commission will now take public comment on items not on the agenda. To give comment, please call 877-853-5247 and enter the meeting ID number 882-7101-2900. Once you've dialed in, please press star 9 to enter the comment queue. The full call-in instructions are read at the beginning of the meeting and are provided on the live stream landing page. And there is no one in the queue at this time, Chair.
Very good. Thank you, everyone, for the early start today. Thank you, Mr. Treichelt, for your work behind the scenes. Thank you to our ASL interpreters. Thank you, staff. Thank you, fellow commissioners. So at this point, we do not have a scheduled Legal Affairs Committee meeting going forward.
Commissioner Yee, who's the chair for next month? Is it Commissioner Sadwani or is it myself?
It is
can't
you,
remember.
Commissioner Toledo.
Okay.
And
Thank you.
those instructions are complete on the stream, Chair.
Very good. There being no public comments, and thanking you all for your good work this morning. This meeting is adjourned.
Thank you.